Hello, on this episode of On Subrogation, we're going to talk about Medpay benefits and personal injury protection, also known as PIP benefits. For On Subrogation, I'm Jason Sullivan of Rathbone Group. The first question is, what is a Medpay benefit and a PIP benefit, and then what's the difference between the two of them? So a medical payment benefit is something under an auto policy of insurance. It's optional in most states that you purchase that benefit will then pay for medical expenses, doctor bills, ambulance bills, emergency room visits, physical therapy, other medical treatment that arise from a motor vehicle collision. Most Medpay benefits are paid without regard to fault, and so if you're injured in a loss and then you have a policy with this benefit, you submit the bills to your insurance carrier, or your doctor will submit those bills, and your insurance carrier will step in and pay those bills up to the amount of the limits of your policy. So then PIP, personal injury protection, covers really the exact same things. It usually covers doctor bills, emergency room visits, ambulance visits, or treatment. And it also covers some things like lost wages, or if you're unable to mow your lawn, personal services, things that you can't do while you're injured. Now, the difference between these two things is that Medpay, for the most part, is a voluntary or optional product that you can purchase when you have auto insurance. PIP, on the other hand, is mandatory in a lot of states. In states like Florida, New York, New Jersey, Kentucky, Michigan, these states that a lot of people commonly refer to as no-fault states, in these states, PIP is a mandatory coverage that you must have when you purchase your auto policy. Now, the reason for that is in these no-fault states, the general provision is everybody buys the required insurance. And so if there's a collision between two people who both have insurance, you look to your own insurance carrier and then they pay the benefits. And under the PIP statutes, the exact benefits are defined. So much is going to be paid for medical expenses. There may be an out-of-pocket deductible that has to be paid, but it's really statutorily created in terms of what will be paid and how it has to be paid. So knowing the difference between the two, you might wonder, do I have Medpay or PIP? And it really is going to depend on what state you live in, and then whether or not PIP is required, or if it's an add-on, that then you talk with your own insurance agent or your insurance company about what your needs are and what insurance you should really have to cover all of your risks. So as an insurance subrogation professional, we've already paid out for Medpay or PIP benefits. And the question now is, can we recover those funds? And there's really two ways to look at it. In a lot of states, you can recover in a direct action against the tortfeasor or their insurance carrier. The person who caused the loss is going to be held responsible. And the alternative, there may be a right of reimbursement or a lien right. And that's where your insured who received the benefit may pursue a personal injury action. And when they do that, if there's a settlement at the end, they may be required to then repay the benefits they received. So there's a lot of nuance and state specifics that you need to know in order to assess whether or not there might be a right of recovery, whether it's a direct claim or whether it's a right of reimbursement. So looking at Medpay, there are a lot of state-specific rules. There are a couple of states that bar subrogation against a tortfeasor directly. So in California and Nevada, those are just two of the states that if you pay out for Medpay, you're not able to pursue the tortfeasor directly. However, in California, it is one of those states where if your insured pursues a personal injury claim and your policy provides for a right of reimbursement, you may have the ability to recoup or recover your lien amount when your insured settles their personal injury case. In other states like Arizona, there are other specific state requirements. There is a $5,000 threshold. So if you pay less than $5,000 in Medpay benefits, you're not going to have a right of subrogation. However, if you pay more than $5,000, you may have a right of subrogation, assuming you meet all the lien requirements and the filing requirements to pursue that amount above the $5,000. Other states, a state where I'm licensed in Indiana, there are more specific rules. You may pursue the tortfeasor, but if your insured files their own personal injury suit, you cannot have a separate subrogation suit. So you can tell just with these few examples, the states really handle Medpay direct claims against a tortfeasor very differently, and you have to look at the state law where the loss happened to determine, is there a right to pursue the tortfeasor? In the alternative, if you can't pursue, as I mentioned, you may have a right of reimbursement, like you do in states in California or in Indiana if your insured were to file a lawsuit and eventually have a recovery. Now, this right of reimbursement is going to be directed by the policy language, by the state law, and it may be subject to some common law theories such as the common fund doctrine and the made whole doctrine. Now, those things are beyond the scope of this short video here, but we will cover on a different topic because they are very important to understand and may affect your right to recovery. Now, for PIP, it's really the same analysis. You may have a direct cause of action against the tortfeasor, or it may be a right of reimbursement, or a combination of the two. So just to give a couple of examples here, if you were trying to pursue a tortfeasor directly, a state like Massachusetts has statute 34M that actually gives a right of subrogation directly against the tortfeasor or their carrier. In Delaware, you can pursue your PIP benefits under some restrictions. However, that has to go through a mandatory arbitration program. Same with Kentucky. There's the Kentucky Inter-Arbitration Agreement, KIAA, in which these PIP subrogation claims against the tortfeasor's carrier are brought. In other states, there's other restrictions. In Florida, New York, New Jersey, there are requirements that a commercial vehicle be involved, or the vehicle must meet a certain size requirement in order for there to be a right of subrogation against the tortfeasor. Another state like Oregon has a combination where you can either seek a right of reimbursement from your insured out of their recovery, or you can pursue independently either through arbitration or through the state court process. So again, just like with Medpay, you really have to have an understanding of what state law is going to apply. Is it the law where the loss took place, or is it your policy state? And then under those guidelines, you'll be able to figure out, do I have a right to pursue, and then is that a right against the tortfeasor and their carrier, or is that a right of reimbursement from my insured in the recovery? And just to kind of touch on why this makes sense, if an insured like me gets into a car accident and I'm not at fault and I incur $10,000 in medical treatment, now, my auto insurer is going to step in and they're going to pay that $10,000, and I'm going to then pursue maybe the at-fault party, the tortfeasor, for my pain and suffering. If I go to a jury and the jury gives me an award for all of my medical bills, the $10,000, plus my pain and suffering, and the other party pays that, and I've also received the $10,000 payment from my own insurance company, I've been unjustly enriched. I've received 2 recoveries for the exact same damages. So that is why there is a right of reimbursement in a lot of states, to make sure that, one, the tortfeasor is held responsible, but second, that there is no unjust enrichment and that the insurance company does recoup from the at-fault party, either directly or through their own insured. Now, there are a lot of different things you have to be concerned with, such as the common fund doctrine and the made-whole doctrine. We'll cover those in another video. For On Subrogation, I'm Jason Sullivan, and that's the long and short of it.